Want to read just a portion of a notice that came to us from Springfield from the Illinois Coalition of End-of-Life Options. It says early this morning, the Illinois Senate approved and sent to the governor's desk Senate Bill 1950, also known as Deb's Law. It's a measure that allows mentally capable, terminally ill adults with a prognosis of 6 months or less to live the option of obtaining a prescription medication that they can decide to take so that they can die peacefully and end their suffering. It is a big deal, and I want to bring in State Senator Linda Holmes, who sponsored this bill. Thank you for your time.
Thank you for having me.
Explain why you moved this forward.
Because there has been such an outcry from people that have wanted to have this measure in place. Basically, it's an end-of-life option. There are several options you have, whether it be hospice, palliative care, pain management, all of these options. This option quite simply says if you receive a diagnosis of less than 6 months to live, you have the option to request a prescription from your doctor so that if the suffering becomes too intense, you can take a prescription and peacefully end your life.
I'm hearing options. I'd like to know what the pushback was as you were advocating for this bill.
There was some pushback. Some people on religious grounds feel that it wasn't appropriate. Some people, there were some claims that those in the disability community were afraid it would marginalize them or they would be coerced into taking this measure. But we do have data from back, a lot of people don't realize Oregon actually passed this measure in 1997. And in that time, there have not been cases of coercion or abuse of this procedure. So that was one thing. But it just took a while to educate people and make sure people understood why this was needed as a choice.
Were there some of those things that you took into consideration that maybe, from the initial form of your bill to where it is now that were taken into consideration and maybe shifted some of the priorities in your bill?
We did. What we did that was especially important was all the guardrails that are in place to make sure it cannot be abused and to make sure that the person, you make an initial request to your doctor verbally. You then have to make a written request. That doctor then has to have another doctor examine you and make sure that the diagnosis, that they agree with it, that you have less than 6 months to live. If either of those doctors has any concern whatsoever that you have the mental capacity to make an informed decision, you then must see a licensed healthcare specialist, mental health care specialist, to make sure that you are knowingly and willingly going into this. So we have all of those measures in place to make sure that there isn't abuse.
And does there have to be someone present when you take that?
We certainly, it's advised that somebody is present, and most people do. What most people do. And I want to also clarify something because people think that you're totally alone in this. Most people that do this, 88% of them are already in hospice care. And most people have their families or a loved one with them because they want to have their loved ones with them. Their loved ones want to be with them. So while it's not required, it is certainly advised. And the patient has to be able to self-administer the medication. Nobody can give it to you. You don't have a doctor that's administering it. It is the patient themselves that takes the medication.
Okay, where do we go from here with this? When does it take effect? What's the next step?
The next step, now that it has passed in both the House and the Senate, is to be sent to the governor. It is then up to the governor to sign it. Once the governor signs it, it effectively becomes law 9 months after the date of the governor's signature.
Okay. All right. Please keep us updated on where things go from here.
I will. Thank you so much.
Thank you as well.